But first, our top story. Initially, there was disappointment and then relief for the Gujarat riots activist Teesta Setalvad and her husband Javed Anand. Denied anticipatory bail by the CBI, which has labelled her a national security threat, Teesta Setalvad did manage to get interim bail from the High Court, but her battles are far from over. Tonight, we look at the allegations against Teesta Setalvad, some very serious, some seemingly outrageous. Well, joining us now for our debate this evening, Hitesh Jain, the Supreme Court lawyer, also with us, Sanjay Hegde, the Supreme Court advocate, with me in the studio, Shaina NC of the BJP, and the former director of the CBI, Joginder Singh. Thank you all very much for joining us. Mr. Jain, let me come to you first. Some of the charges against Teesta Setalvad are very, very serious. Some of them seem to be rather strange. We'll go into all of the allegations, there as many as possible. But sir, why and how does she represent a national security threat? That's what seems difficult to understand.
Well, I think national security threat and all is a bogey which Teesta is making. If you will look at the FIR is a comprehensive FIR for receiving the funds illegally and then siphoning them. Now, basically, when a person is running an NGO and you are indulging into all kinds of violation, and this FCRA Act is a very serious act. It has some serious consequences for its violation.
Right.
The whole idea is that there should not be any misuse of funds and other thing. So we have to look at the FIR in the perspective and not in this isolation of this one allegation.
We will look at FCRA as well.
If 4 or 5 allegations made in the FIR are serious enough, then we should take it at that.
Sir, but
and we
why
should not
would
allow the seriousness of
filed
FIR
by
to
the
diminish.
CBI say something as ridiculous as the motive behind the transfer of foreign contribution to Sabrang Communications is highly objectionable and reflects interference towards the internal security and activities of India. Such acts of foreign donors may be likely to prejudicially affect security, strategic, scientific, economic interest, harmony between religious, racial, social, linguistic or regional groups, castes or communities or public interest. We'll talk about the very serious allegations against her, sir, and there are some. But why is the kitchen sink been thrown against Teesta Setalvad?
Okay. Let me answer. First is to running the vilified campaign. Second is to create disharmony between the Hindus and the Muslim. Third is to specifically bribe the witnesses and to make false cases and try to disturb the communal harmony and peace. Now, if these charges are not if these acts are not serious enough,
so what racist thing has she done? What linguistic thing has she done?
To divide, to disturb the peace between the two communities and to file the false charges and to run a vilified campaign.
She's indulged
we cannot
caste
get into
warfare.
Yes, she has been indulging. That has been a charge. That in fact, one of the witnesses have complained. There have been 2 or 3 witnesses, and there are people who have worked with her NGO. They have also complained about their conduct, activities, bribing. In fact, in one of the case where I was representing some accused, when we were cross-examining the complainant said, she said that I don't know anything. I was signing. Teesta Setalvad used to bring the papers, and I was signing at the point blank.
These are valid points that you're making.
What is the motive of Teesta Setalvad?
Okay. We'll get to these allegations that you're making, but just the first set of allegations in the FIR that she affects linguistic regional groups, harmony between racial communities and the like, the security strategy. Does Teesta Setalvad, is she that strong that she represents a threat to India?
Well, I don't know what exactly the Central Bureau of Investigation's idea of India is. If India is a majoritarian state about one community only, and if any party which wants an investigation into an event that occurred in India so many years ago constitutes a threat to that idea of India, well, maybe Teesta then has to go in, if that is the India that we are building. Now, sorry. What is happening essentially is that you are throwing the kitchen sink, you are throwing words, you are throwing allegations, you are throwing everything at her in the hope that something sticks. The allegations from the affidavit says that no, she went and bought Mills and Boon books with the money. She bought wine with the money. Just tell me this. Is Mills and Boon a crime? Is Archie Comics a crime? Or
an expensive hairdo at Rome and in Pakistan?
Mr. Hegde, siphoning of fund is certainly a crime.
Siphoning of funds is
the charge is.
Listen,
don't trivialize by saying wine or Mills and books.
Mr. Jain, I am quoting from your affidavit.
And use the funds for his
Mr.
personal
Jain,
use.
I am quoting from your affidavit. Number one. Number two, as far as siphoning of funds is concerned, entirely it comes down to accountancy. Please tell me what accounting crime requires you to take a woman into custodial interrogation. I do not recollect any kind of custodial interrogation which was required even in the
custodial interrogation.
Why do you need custodial interrogation?
Anticipatory bail application on her own volition. CBI has never told that that they will be taking custodial interrogation, but there are in so many cases, day in, day out we defend, in the cases of forgery, in the cases of 2G, Commonwealth, they were all based on documentary evidence. But then the custodial interrogations was granted, and even the Supreme Court felt that the custodial interrogation is necessary to look into all other acts and to see what are the, as to how the offence has been committed. So, I mean, we have to look at the facts in totality and not look at one fact here or there in isolation and then trivialize the charge.
Okay, I just want to, I want to go into the FCRA part of what you said, because that's one of the allegations which has been raised over and over again. And the allegation is that she had received funds from abroad, from the Ford Foundation, and that she wasn't allowed to actually access those funds and use it. She was allowed to get the funds, but she wasn't allowed to use it for the purpose that she was actually using it for. But the point is this: Section 3 of the FCRA prevents her from receiving those funds, but Section 4 of the FCRA says that those funds could be used if it was for the purpose of paying salaries. So therefore, sir, you are quoting, Mr. Jain, one part of the FCRA and not perhaps looking at the other. That's what Teesta's side has to say.
No, in fact, in the FIR, if you will see, the charge is of 4(1)(b), because Teesta cannot act as a publisher. There is a strict condition that you will, when you are receiving the fund, you cannot act as an editor and publisher of a journal. So the charge is that the Teesta and her husband both are indulging into that. So if you look at from that perspective, there is a charge of violation of Section 3, there is a charge of violation of Section 4(1)(b), and there is a charge of violation of Section 11 also for not obtaining the certificate.
But sir, Section 4 says nothing contained in Section 3, which you just spoke about now, shall apply to the acceptance by any person specified in that section of any foreign contribution where such contribution is accepted by him, subject to the provisions of Section 10, by way of salary, wages or other remuneration due to him or to any other group of persons working under him from any foreign source, or by way of payment in the ordinary course of business. So, sir, it's obviously you've got another interpretation of this, and sir, as a lawyer yourself, I'm sure you are best placed to argue this. I am only asking the larger point. If there is this divergence in understanding or interpreting the law, does it really warrant her being potentially put behind bars for custodial interrogation for something like this?
First thing, Vishnu, the application for anticipatory bail has been filed by Teesta Setalvad on her own volition. She is sensationalizing. I don't think CBI ever said.
Is Mr. Jain saying that she will not be arrested?
They conducted the search.
Are you saying that she will not be arrested? You're prosecuting her, aren't you? The law will take its own course, and if the investigation authorities feel that the arrest is required, then it will be their prerogative.
No, but sir, do you believe?
Prejudge. Let's not prejudge. But let me answer your question on Section 3 and Section 4.
Yes.
The charge is Sabrang Trust receives the money, then transfers the money to Sabrang Communication. Now, if you will look at this, the receipt of funds, and then the subsequent diversion, and then to use the funds for the personal expenditure. Now, this if you will look at the facts in total perspective, constitute an offence under Section 3, a violation of Section 3 and Section 4 of the Act.
How many other NGOs have you gone after like this? How many other NGOs?
For
instance, let us also take the Saraswati Shishu Vidyalayas, we are getting a lot of money from abroad.
Let's make logical arguments on the facts.
Let's
look at the logical arguments that receipt of funds and siphoning of funds.
Listen, as far as the money transactions are concerned, she will certainly explain. The question is, why are you making such a mountain of a molehill? You essentially, what has happened, has any of the donors, has Ford Foundation objected? Has any donor objected? No. Now, please also tell us that out of all these other NGOs,
I don't think
how many
objection
NGOs
of a donor is a requirement of the law. Okay. Let me give an illustration. Suppose if a donor makes a donation in violation of Section 3, does it mean that he is not objecting? That means there is no offence that is occurred.
No. The question is,
I just want to prevent this being, just a back and forth between the two of you, Mr. Jain. Mr. Jain, I want to move on to other points and I'll come back to you in a moment. But Mr. Jain, very briefly, you mentioned a point that she may not be arrested, right? Is that what you're trying to say? That there may not be a requirement for custodial interrogation.
It will be purely CBI's call. And if the investigation requires, and if the investigation authorities feel that custodial interrogation is required,
do you believe there is a requirement,
At the end of the day, these decisions are not easy decisions, and they are required to justify these decisions before the court of law. So we are living in we have a strong, robust criminal law justice, where it is not easy to arrest a person on the whims and fancies of the officer.
No, but Mr. Jain, I'm just asking you,
and then justify the arrest before the judicial authorities.
Taken into custodial interrogation. Do you believe so?
Well, if the we have to look at the investigation, and this is the decision the investigating authorities should answer. And if the investigation justifies her arrest, then she should be arrested also.
Okay, Joginder Singh sir, I wanted to come into a few more parts of what the Gujarat police, because all sorts of allegations, have told the Supreme Court. They have said that 2002 riot victims were used as poster boys to raise 6 to 7 crores by Teesta Setalvad. This 6 to 7 crores was used for personal expenses, consumption of liquor, wining, dining, an expensive hairdo at Rome and in Pakistan. And this hairdo was put under the category secular education or legal aid expenses. Now, sir, prima facie, sir, this appears to be a serious misdemeanor on her part. But surely, sir, even if this is a massive misdemeanor, she doesn't need to be put in custodial interrogation for this, sir. She's put her hairdo under secular education or legal aid expenses. That could be a mistake. It could be deliberate. It could be a huge offense. But should she be behind bars for this, sir?
Vishnuji, I don't think Ford Foundation gave her the money for getting her hairdo done.
Why don't we ask Ford Foundation that?
If the allegation the Gujarat police has made is true, I am not holding any brief for anybody. But the fact remains here that even as per the rule, they can accept donations only after it is registered in the FRCA. So it has not been registered in the FRCA. This is the Home Ministry sent a team in June 2015. They were not satisfied with the reply. It is the exact date they were asked to, Stitsa was asked to give reply by 19 June. They were not satisfied with the reply, so they passed on to CBI. Now, whether the investigation done is fair or not is not for any one of us to see, except for the court or the supervisory officers of the CBI. It is true that CBI is a wing of the government here, but I think in functioning, when the courts are supervising this case, and the court had set up a Raghavan committee also for this thing here, they didn't find much fault with any of the
I want to go across
government here.
So
now,
I want to
limited question here is I just give me half a second. Limited question is she did a good job in raising the criminal rights issue, but what started it? 59 persons, including 44 men, I think 13 women and two children who were burnt alive.
But sir, you're looking.
So every action has a reaction. I'm not looking at it.
I'm sorry, sir.
The whole
every action,
has a form,
which is not
Mr.
justifiable.
Joginder Singh, you're a former director of the CBI. You're saying that every action has a reaction. Are you justifying or finding an explanation for what happened in
Gujarat? I would not justify it. But this is the law.
Sir, was it okay for the violence to have taken place in the manner it did?
No, I don't justify even
Vajpayee. Then what are you saying, sir?
The Rajya Dharma should no. What I am saying here is this is what led to the whole thing here. We have to be tolerant of each other instead of finding fault with everybody here.
Well,
saying that you are wrong or I am wrong.
I think any death in Gujarat is deeply tragic, and I'm sure we all agree.
Why in UP, in Shamli and Muzaffarnagar?
All right, so I want to move on now because I'm not sure where you're heading with this. But Shaina, I want to ask you this question. Now, one of the central allegations which has been made by Teesta Setalvad is that the Zakia Jafri final case begins on the 27th of this month, and all of what is happening now is part of an effort by the centre to ensure that these proceedings don't function well. She may not be present for that if she is behind bars, and therefore she directly alleges the involvement of the centre in affecting the courts or the investigation process. How do you respond as a BJP?
She has every right to make allegations.
Shaina, go ahead.
It's a baseless allegation, and she was pulled up in court for having said so. We believe clearly in an honest investigation, and I think it's very convenient to say that, if she gets bail, then it is absolute free and fair judiciary, and if there is a question which comes up to suggest that the Honourable Court feels she is not applicable for bail, then it suggests that, the government is after her on a witch hunt. Please understand that you have legal experts dealing with this case, where you have an absolute presentation made by the Central Bureau of Investigation. If there are facts to suggest that 1.8 crores of foreign funding from organizations such as Ford were given to her NGO, out of which 80% were even spent just on office expenses, is it not something that the court can question? Are there not other facts to suggest that yes, there have been misappropriations? I don't want to sit on judgment because I am not a legal expert. You have two on your panel. You have a former CBI director. I only want to say on behalf of our government,
I will give you
we believe
more
in
information.
Free and fair trial, where let the legal proceedings take shape the way the Honourable Courts feel fit. If they feel she is applicable for bail, so be it. If not, then for whatever reasons, the Honourable Courts will decide. But to suggest that the government is on a witch hunt and for her to say that these are the powers that want us out is all baseless allegation.